This is 202 West 5th Avenue, Park offices, and this is loft right across the street. It's a 2x4 studding, some new frames, straighten everything out. It's put in plumb, put a plumb to it, put a level to it, to the increments here, you put it in brand new fence line, let it pour concrete, let it fit, let it dry, let it cure, and it's at 70 degrees, 80 degrees, 90 degrees some places. A lot of asphalt in there, and like 110, 105 degrees on asphalt. Just walked up on it, it's hot. Let's figure this out. We got the table of contents, U.S. Court of Appeals 11th Circuit, March 5th, 2019. 2019. This U.S. Court of Appeals of 11th Circuit, March 5th, 2019. Table contents is Quality Auto Painting Center of Roseville, Inc. versus State Farm Amenity Company. The new verdict, legal analysis and commentary. Mumu and Ganja's commentary. That's a Vacan. Mumu and Ganja. Trump, T-U-R-M-P. Mumu and Ganja's commentary. Moon got a commentary. It says, counting the collective harm of missing women's work. Robin B. Carr, Leslie Wexler, the light of recent revelations. It says, the light recent revelations about Ryan Adams, a powerful musician, a music producer, and Illinois law professor Robin B. Carr and Leslie Wexler discuss the collective harm of scourge of sexual harassment inflicts on society, depriving it countless and valuable contributions. Carr and Wexler point out the research demonstrates an experience of sexual harassment causes not only individual harms to women, such as decrease in mental and physical well-being, also organized withdrawal, decreases organizational comment, and decrease of productivity and job performance. Exact losses due to withdrawal have yet to be measured, but evidence suggests a magnitude is enormous. U.S. Court of Appeals 11th Circuit opinion. Quality Auto Painting Center of Roseville, INC versus State Farm Amenity, docket 15-14160, 15-14162, 15-14178, 15-14179, 15-14180, March 4th, 2019. Areas Law, Antitrust and Trade Regulation. Judge Anderson, A-N-D-E-R-S-O-N. The body shops filled with suit allegedly defendant insurance companies conclude the lower repair prices by improperly pressuring the shops to lower the prices by threatening and boycotting those who did not comply. The body shop complained per se pricing fixing conspiracy and per se conspiracy and boycotting and well state law claims. 11th Circuit affirmed the Circuit Court dismissal of all body shop federal antitrust and state law claims except the tortoise inheritance claims. A slow turtle, a slow individual, a slow monotonous sloth with unperformed or obese overweight, big mouth, fat tissue in between the brain. Although the court held in just enactment quantum merit claims, boy shops mere wholly without merit. The court vacant discount court judges as the tortoise interference claims. This fat sloth obese individual in the middle of the conhoose were down him disbarred, a lost and distraught fool in the public eye of 90 billion people, downgraded to 90 million people. Adherence calls this individual a tortoise sloth. Claims because the court was pursued by the district court to conclude this allegation of tortoise adherence in each of these 5 cases violated the group planning doctrine, failed to give the fair notice to defendant the claim being made against it. The court remanded further proceedings. U.S. Court of Appeals for the Sixth Circuit, March 5th, 2019. Table of contents would be Lawrence Walber Jr., bankruptcy. Sanpuri versus Armand, civil rights, constitutional law, criminal law. And put this on Front Street, all of them filed bankruptcy. And this is the new verdict for Mumu Nganja, Vok Donald Trump, and Melania Trump, and Tiffany, and also Barron Trump. And that's all. This is Eric. And this has regulations on Mumu counting on the legislative verdict, new verdict, legalized commentary. Putting you on Front Street. It says collective harm, missing women's work. It says Robert B. Carr, Leslie Wexler. Collective. Ennis Collective. Ryan Adams, powerful musician, music producer, Illinois professor Robin B. Carr, Leslie Wexler, discuss collective harm and scourge and sex harassment. U.S. Court of Appeals and Six Opinions. R.E. Lawrence Waller Jr. Docket. Mr. Lawrence Waller Jr. Docket 18-8008. March 4, 2008. Judge Humphrey. Judge Humphrey covers the areas of law. U.S. Court, Sixth Circuit Court, and Sixth Circuit Court. After settlement, divorce, the proceeding debtor filed Chapter 13 bankruptcy petition. Was successfully fined jail to failure to pay court-approved settlement. Debtor filed adversary complaint seeking dangers under 11 U.S.C. 362 violation of automatic stay by former wife Scucco and her attorney Gentles by allowing the position and petition sent on this portion and petition contempt proceedings of contempt despite knowing the automatic stay was in jail. The bankruptcy court found no violation because of the two did not take affirmative action post-petition to try to collect and debt, and there has no affirmative. That'd be Central Bond at Aquatic Center in Moses Lake, Washington. Judge Judith Warnick and Mr. Dent. The affirmative bankruptcy found violation here in Moses Lake, Washington, 401 also. They have the debt affirmative action petition and collective and debt. There is no affirmative action could prevent domestic relation judge from jailing debtor for non-pay because of contempt motion already unrolled upon. International airport, just fly him in. Here in Moses Lake, Washington. Debtor and non-payment because of the payment already ruled. Sixth Circuit brief from pallet panel reversed upon filled debtor bankruptcy. Increment Gentile and Skur, in relief of the stay of bankruptcy, determined that the stay apply cannot idly appear collective proceeding debtor and jailed because did not pay the judgment creditors discharged debt. The burden was the creditor and her attorney to stop the proceeding once bankruptcy was filed. Ms. Sarpa and Ormond, docket 176048, 176166, 176213, 176260, 176299, 176333. March 4, 2009, Judge Jeffrey C. Sutton. Mr. Sutton and Jeffrey S. Sutton is the judge for this areas of law, civil rights, constitutional, and criminal law. 5 federal prisoners filed corpus petition 28 U.S.C. 2241, argued that the respective sentences are too long for U.S. federal laws. Each paid $5 for corpus filing fee district court, and each lost petition on each merit. Each man moved the proceeding on pauper would be on the appeal, seeking to avoid prepaying $505 pallet filing fee. Statute 28 U.S.C. 1915 A1 says the federal court may authorize commitment, prosecuting defense, and the suit action proceedings civil and criminal, or appeal therein, prepayment of fees by person who is unable to pay success fees after examining each petition and find out the statute district courts grant the motion requiring each petitioner to make one of those times. Courts granted motion in part require each petitioner to make one partial and partial repayment of the fee ranging $50 to $400. For the Sixth Circuit affirmed the statute deprived district court and disagree require repayment, appeal, fine, and nothing. This deprives everything in show causes. Conway versus General Electric, Civil Procedure Environmental Law. United States versus Galloway, Criminal Law. Remember, Mumu Ganges counting about Donald Trump and about Melania Trump, bearing also administration office. That has the firms and Eric and Mumu Ganges memo. U.S. Court of Appeals for 7th Circuit, Conway versus General Electric Company, docket 181522182880, March 4, 2019, Judge Joel Martin Flom. Areas of law, civil procedure, environmental law. Plaintiffs purchased land near former General Electric manufacturing plant and operated on Morrison, Illinois for 60 years. John Deere Evergreen Implement Contract, Illinois, Morrison, Illinois, and Moline, Illinois. 60 years, planted toxic chemicals agents filed suit under statute law General Electric 2004. Sputnik Equipment, General Electric, Blackfoot, Idaho, and also the 5 and the small pups, harvesters, and connected to the Lockwoods and 95XC RX 9540, and also the 95 SSTS. These are RT tanks, RX, and implementaries for 35 maximum speed on highways. These investigations developed plan to address containment in 2004. And this is John Deere Evergreen Highway 26, Othello, Washington, Highway 17, RDO Pioneer Way, Moslake, Washington, R210 West Broadway, Rissville, Washington, 99169, P.O. Box 187, 210 West Broadway, Adams County, Rissville, Washington, 99169. John Deere Evergreen Implement RDO. Owners. Plaintiffs have filed suit under Citizen Supervision Rescue Compensation Recovery Act 42 U.S.C. 6901, seeking mandatory injunction under General Electric, John Deere Evergreen, and that's Sputnik Equipment, and that's Idaho. And this is Congerland Weston, Washington Potato, Warden, Washington, Pasco, Washington, Kennewick, Washington, Richland, Washington, and all CHS and Railroad Transport from Warden to Findlay, Kennewick, Washington. Black Panther High School, Findlay, Washington, Hanford High School, Southridge, the most powerful white minority group in the world that kicked the bomb of black minorities out of universities and campuses and all law schools. Illinois Environmental Protection Agency filed water substances. This suit under state law against General Electric in 2004 has been working for the company since the investigator developed plans to address containment in 2013. Plaintiffs filed suit under Citizen Supervision Rescue Compensation Recovery Act 42 U.S.C., Hanford High School, and also Washington State University, with all cannabis, ganjas, marijuana plants on my plantation, Yakima Reservation, Dabra Hotel, Historic, and that's Donald Trump's, here's Trump, Mumu Ganges, 42 U.S.C. 6901. Seek a mandatory injunction under General going down on her. Straight going down on her. 690142 USC. Only white females. White blood cells, red cells, no hepatitis, no AIDS, no gonorrhea clap, no syphilis, no preliminary 6-month lapse of AIDS, no diseases, no allergic reaction. Look at this. 42 USC 6901. seek a mandatory injunction on a general let conduct additional investigation scope containment of ordering company remove containment. District court found company table liable. Containment summary judgment deny injunction relief. Despite many opportunities, plaintiffs no offer evidence that established injunction beyond the relief of company Ivanka, Donald Trump, and Melania over International Airport in Moses Lake, Washington. Just leave them. Yeah. Just leave them there, man. Just leave him for dead. Let him rot. Let him hang on that tree. Just cut his hands off. He's at Findlay, Washington. Yeah, just make it clear. Oh, they're going to recognize him. If his body's floating, all those, Oregon will identify him. All the barge, wheat movement at the Blue Bridge, at the Cable Bridge. No. It's overnight. We got 2 hours. Maybe we can just burn his body up and chop his body in pieces and just bag him up. Yeah. Didn't work out for him.